Doug, it's really interesting as to how much you, with AG in Nebraska, pushed forward on this particular case or many others that surround Alphabet at the moment. And it was under the previous Trump administration that first kicked off in 2020. What impact, remind us, does this have on the consumer, on the tech industry at large, this sort of form of control?
I think the biggest issue that, as Attorney Generals, that we had concern about was that big tech was accumulating so much personal data, and that data really presented the consumer almost as the product, because the data was what fed search, it's what feeds AI, and really we felt as AGs that we needed to step forward because their privacy and the use of their data for profit was a big concern.
Let's talk about, therefore, the consumer in this scenario, because Google would counter that this is going to hurt the consumer. If you separate, for example, Chrome off, suddenly that seamless approach, if you're an Android user, if you're a Chrome user, disintegrates. Does that ultimately hold firm in your mind?
You know, I don't think so. I think one of the biggest concerns we had was that what Google did in maintaining, and this is in the judge's August opinion, in maintaining its monopoly, it basically created this ecosystem where they entered into exclusionary contracts with all the important players, had some revenue sharing with those, which were very important. And then as a result, they create this basically this feedback loop that keeps everything contained within Google. And the result of that is it disincentivized anyone from the outside actually being able to get any capital to challenge with a certain type of search engine that may be a better product, may better protect privacy. All of that is pretty much locked out because investors weren't going to invest in someone who's going to go up against Google. And second of all the players within that loop that they had through these exclusionary contracts, you know, were disincentivized to look at working with any other technology. So frankly, I think it's put a 10-year hold on really developing better search technology.
Interesting. I mean, Eddie Q is going to be giving evidence from Apple. They get about $26 billion a year in terms of payments to be offering that exclusive nature of Google as a search option. But there are other companies out there, other search options that actually get money from Google too. What do you think we'll hear in terms of some of the evidence given this week?
Well, I think there's several things. One, I think the court in its August opinion made some really important findings about the effects of these revenue sharing contracts. I think the court also really realized the importance of scale, because having that data and Google being able to acquire so much of that just builds a scale that actually makes it very difficult for any competition to occur. So I think we're going to once again see evidence about how companies who wanted to develop products in general search and also in the area of search advertising, text advertising, we'll see evidence of how they've been kept out of the market and how it's necessary, including the divestiture of Chrome as an important element to balance out competition in the market.
Alphabet shares currently at session lows, off by 2.5%. They've got their earnings later this week, so Sundar Pichai is a busy guy. Doug, I'm interested, though, in what the countering nature from Google also is. This is backward looking. We suddenly got a lot more competition in the search space because OpenAI is there and all Perplexity, these other generative AI forms of search. Is that an interesting argument? Is the timing wrong here?
Well, no, actually, I think the timing's really important because I think we both, the Department of Justice and the state attorneys general, recognize that technology is moving so quickly. AI is moving very quickly. But what's the fuel of all of that, once again, is data. And so we think actually part of what we're asking for in the remedy is to ask the court to keep a monitoring process going so that we can follow this as we go into the AI world development, because it really, from a Venn diagram, there's a lot of overlap. And so having an ongoing monitoring ability by the court will allow us to address some of the new technology challenges that might come forward.